Good afternoon, everyone. Welcome back to Civil Procedure. Okay, so we're in the middle of talking about motions. Okay, so motions. This is, of course, the third step on our conventional civil action road to justice. And we started talking last Thursday about all the different forms that that motions can take, right? So we looked at this motions family tree. I won't drag you back through this in excruciating detail, but the top level distinction, of course, being between, on the one hand, procedural motions, which are about how the civil litigation should proceed, and then substantive motions, which are about the real world, asking a judge to make a decision either about how the litigation should go forward or a decision that will affect what's actually going on outside of this weird and wonderful world of civil litigation. So we went through this case last time, the RJR-MacDonald case, and that was all about injunctions, interlocutory injunctions. So people who call this is what happens, this type of substantive motion when a party is seeking some relief to be granted for the time being, pending final adjudication of the case. And we went through the sort of unique constitutional context of this tobacco control litigation, but we got to this test, the RJR-MacDonald test, which is in fact the test for all interlocutory injunctions granted in civil actions in Ontario. And you had a question, so it's Bob's Burgers, right? And Bob's introduces this submerged sandwich, and then Bob's business rival, Steve's Subs, decides that this idea of the submerged sandwich will confuse its customers, right? So they're saying this is an illegal form of competition. So Steve's sues Bob's Burgers, and they say there's illegal competition. They've infringed on the intellectual property. We've got a trial scheduled in November 2016, and then Steve's, pending that trial, brings a motion. They're seeking an interlocutory injunction forbidding Bob's Burgers to advertise or serve this sandwich pending the outcome of the lawsuit, pending the trial. So Bob's Burgers is responding to this, right? So Steve's is trying to stop Bob's from doing this, from launching this product, and they're trying to do so via an interlocutory injunction. So they want this to be an order the court makes for the time being until the trial happens. Bob's is responding to that, and they're trying to stop this, prevent this interlocutory injunction from being granted. So the idea here was to think about how all of these different arguments that Bob's might make fit into this RJR-MacDonald test. Okay, so I think maybe I'll just sort of show you how this works from branch one going forward, because this is a complicated and kind of tricky test to apply. So the first branch requires the moving party to demonstrate that there is a serious question to be tried. So the moving party, the one who wants that interlocutory injunction, has to show that their lawsuit will have some chance of success at trial. Because if you let plaintiffs bring lawsuits and then the lawsuit could be completely spurious, like Jian Gomeshi's lawsuit, for example, against the CBC, and then we were willing to grant them interlocutory injunctions for those groundless lawsuits, that would be a serious injustice to the defendant. So you don't have to, for the plaintiff trying to get an interlocutory injunction, you don't have to prove your case fully, but you have to at least show there's some fragment of reality to it. So for that, I was looking for this one, for RJR branch number one. Then we move on to the second branch of the test. The applicant has to show that they will suffer irreparable harm if the relief is not granted. Because no matter how badly the defendant has treated you, no matter how grievously your rights have been infringed by the defendant's wrongful conduct, if you can wait till trial to have those rights vindicated, then you're going to have to wait to trial. The only circumstances in which we're going to be granting you interim relief without having heard the evidence in its full is a case where you really cannot be made whole if that much time passes. So that has to be irreparable harm. That's where this one comes in here, right? So Bob's, the defendant, they've painted these big murals, right? They're going to launch this advertising campaign for their new sandwich. And if you were to grant that interlocutory injunction to the plaintiff, it would mean painting those over, and that's going to cost money and cost them time. Sorry, I take that back. This is branch number 3. See, I get confused here too. This is B, right? Irreparable harm. So here Bob's would be saying that that whatever damage Steve suffers can be remedied fully after the trial, right? So no matter how bad it might be for Steve's, even if we've done something wrong, that can be fixed after trial, right? So this one here is for branch number 3, the balance of inconvenience. So the balance of inconvenience part is all about who's going to be more put out if we get it wrong at this interlocutory injunction stage. Because the premise, the assumption with interlocutory relief is that we're more likely to get it wrong here than we would be if we had the benefit of the full trial record and all the trial evidence. So given that we are a bit more likely to get it, the court's a bit more likely to get it wrong at this stage, who is going to be more put out, right? If we do get it wrong. So that's where this one comes in. And this stuff about irrelevant gossip, this is where the pleading would be struck, and you would use one of those remedies that attacks the pleadings directly instead of having to work that in to the RJR-MacDonald test. Yeah, so put out is a matter of inconvenience, right? That's of being required to do things. So remember when RJR was talking about all the reasons why we shouldn't have to. So when RJR was running this test, right, they were saying that the balance of inconvenience favors us because if the government's tobacco control legislation is found to be unconstitutional, then we will have had to. If we have to comply with it, then we'd have to like change all of the marketing displays in the convenience stores and redesign all the packaging and so on. So RJR said that if you don't grant us interlocutory relief, then we will be greatly inconvenienced if the final judgment goes the other way. Whereas RJR says if you do grant this to us and then decide ultimately that the feds are right, then they haven't suffered much inconvenience. The only inconvenience, according to RJR, to the feds would be that a few people started smoking or continued smoking in the meantime. So it's all about who's going to be worse off if the interlocutory injunction ends up going one way and then the final trial judgment goes the other. Okay, so not easy stuff, but that's it's all a consequence of the time that it takes to get through civil litigation and the reality that we cannot insist on parties waiting for final adjudication, but at the same time granting remedies without the benefit of a full trial has negative consequences, especially if you end up getting it wrong or end up making a decision which you then go against in your final adjudication. All right, so there were a couple more questions here that I wanted to look at. I think, yeah, this was all about old stuff. So set number 5, a difference between a notice of motion and a statement of claim. So most people got this. There were a couple here that were not quite right. Yeah, so this is all correct. There's a difference in the level of service required. Statement of claim and notice of motion serve different functions. We start the lawsuit with a statement of claim. A motion, of course, a motion can only occur after a statement of claim has been filed, because a motion is a request for adjudication within an action, and no action exists until a statement of claim has been filed and served. What was the one I wanted to look at here? Right, so this is not correct. A statement of claim is not a type of motion. A statement of claim is a type of pleading. And this is also not correct. A notice of motion is not an order from the court, right? A notice of motion is the document by which you request that order from the court. And then that will be followed by the court order. Okay, so let's get into Henco, right? So Henco versus Haudenosaunee. So, you know, RJR was a big, tough, complicated case. This other one, these are probably the two real beasts of the course when it comes to complex case law. So I guess we'll sort of go through Henco, and we'll talk about Rule 60 and contempt in the context of Henco versus Haudenosaunee. Okay, so this case, it's about interlocutory injunctions, right? And it's about contempt of court, but it's also about bigger civil procedure ideas, right? So it's about procedural fairness, how we try to use the system and deploy judicial power in a way which is fair to both sides. It's also about party control, right? So this is an important principle of civil procedure that we've mentioned a couple times already, whereby the parties, not the judge, are fundamentally in control of the dispute, right? So you can, whether or not you choose to file a lawsuit is, of course, up to you. Once you're in a lawsuit, you can do almost anything on consent with the other party, right? So all of these like the deadlines for filing pleadings and being allowed to serve documents in one way or another. Generally, if the other side consents, or the other parties consent to what you want to do, then you can go ahead and do it. You can also, of course, settle your lawsuit, drop your lawsuit whenever you want on whatever your terms you want. And the court's not going to stop you just because they think you're making a bad deal or because they think you're giving up important legal rights. Finally, if your pleadings are inadequate, right? If they don't tell the whole story, then the judge is never going to read these pleadings and say, well, wait a minute, paragraphs 14 to 17 are scurrilous and they don't disclose a proper cause of action. I'm sending these back to you, Mr. or Mrs. Plaintiff. You better fix this up. Never going to happen, right? The judge will not act on that unless another party brings a motion and brings that to the judge's attention. So in Henco versus Haudenosaunee, we see the limits to this party control principle, right? We see an exceptional set of circumstances where a judge is kind of taking things into their own hands. So it's an important principle, but this case kind of shows one of its limits. And then, of course, this case is even bigger than just civil procedure principles, right? Because it's a case about Indigenous rights. It's a case about the boundary between the court system and democracy. And it's also about the rule of law. right? What does the rule of law mean in the context of civil litigation, and what are the limits on the rule of law? Okay, so I'll give you the background to start off with. This the case involved the Six Nations of the Grand River, who were the Mohawk, the Seneca, the Oneida, the Cayuga, the Onondaga, and the Tuscarora nations. They were allies of the Crown in the American War of Independence. They helped the British government fight the Americans in between 1775 and 1783. And they were so important and so effective in that war that in 1784, the Haldeman grant was made, right? So this entire gray area was granted to the Six Nations. So it's clear that this area was granted in 1784. It was somewhat unclear what the terms of the grant were. Was it a grant to own all this land outright, or simply a grant to occupy it? That was never resolved at the time. But over the course of the next 200 years, various chiefs of these Six Nations groups transferred the land, to parts of the land, to farmers and settlers. And there were disputes about whether those transfers of land were coerced or not. Like sort of transferred at gunpoint or not, and some of the land, there's evidence, was simply stolen by settlers. So that's the Haldeman Tract. This red area right here is the current Six Nations Reserve. So as you can see, it's a far smaller area than what was originally subject to the Haldeman Tract grant. So in 1976, the Six Nations file a lawsuit against the Crown and against the Government of Canada, the Government of Ontario, seeking an accounting for what has happened to all of this land and seeking compensation for the loss of the land. So 1976, the lawsuit starts. By 2006, that litigation is still not resolved, right? So talk about the slow pace of civil litigation, that's 30 years. And there was a great deal of frustration among members of the Six Nations about the slow pace of this process and the lack of any concrete outcome. And in particular, they were frustrated about continuing residential development in the gray areas around here, which they thought was sort of permanently undermining their rights, right? So you file a lawsuit, nothing's happened for 30 years, and meanwhile, lots of new things are being built that around here, which they had reason to believe was going to make it far more difficult in the long run, even if they were successful in litigation, to retrieve some of this land, which they say has been stolen. Okay, so enter Henco, right? Which I thought was going to be a poultry company, but it's not. Instead, Henco is named for these brothers, right? Don Henning and John Henning. And they are residential property developers. So they have planned a subdivision, right? They want to build houses in an area which is outside the current reserve, but in part of the land which is claimed by the Six Nations. So they buy the land. They apparently follow all of the normal rules for residential development. But after they've sort of started, a protest begins in February of 2006. Members of the Six Nations begin a protest. They occupy the site where Henco is trying to build their subdivision, and they block the entrance with this blockade here so that the construction trucks couldn't get in. There was also and this is the name of the group, the Haudenosaunee Confederacy, which formed to lead this protest. There was also a counter-protest by local non-native residents who were angry about the occupation. Okay, so Henco has borrowed a pile of money and they've hired workers, but they can't proceed with their subdivision as they planned. So what did they do next? What was Henco's first move in this litigation? they brought a motion without notice for injunctive relief. So we're starting here at page 20 of the judgment. Okay, so they brought a motion without notice for injunctive relief. So what does this mean? I mean, we hopefully know by this point what all this civil procedure verbiage means. Can someone tell us in their own words what kind of motion this is and how it is distinguished from other types of motion? It's on the family tree. A motion without notice, also known as ex parte notice, ex parte motion. Right? You don't serve the other side with your documents, and basically they don't know that it's happening. So it's not clear to me why notice could not have been given. Typically, motions without notice are very exceptional because they violate the audi alterum partem rule. But for some reason in this case, they brought this, and in fact, it was granted. So a little bit of perhaps background that's maybe necessary to know here about the right to protest, right? So in Canada, the Charter guarantees the right to peaceful protest. But that right to sort of assemble and conduct a peaceful protest is generally strongest only on public space, right? Like so in like the grounds of Queen's Park or a public park or so on, you're likely to have a constitutionally protected right to assemble peacefully in those places. When it's a protest on private property, right, as this one was, the Charter's guarantee of that right to assemble peacefully is much narrower. And that's why the Charter was no apparent impediment to this order that was granted on March 3rd of 2006, where the order was granted to cease the occupation, take down the barricades, and don't interfere any further with construction. Right. So this is an order of Justice Matheson. So this was an unusually quick turnaround for civil justice. Right. The protest started on February 28th, and within a week, this order is granted without notice even being given to the defendants. So Justice Matheson also provided for service of this order. Can anyone remind us of the definition of service in civil procedure? Putting something into play was kind of the metaphorical allusion, but it's the delivery of documents, special rules for the delivery of documents used in civil procedure. So we talked in the service unit about service of pleadings, service of notice of motion, and so on. But court orders must also be served in some circumstances, right? And so in this case, because of the unusual circumstances and the fact that the protesters had no notice of the motion, there's a special order made by Justice Matheson about how his order is to be served on the defendants. Can anyone tell us what that was? What did he say about how his order should be served?
So the sheriff tried to deliver the order to the protesters on March 5th, but the protesters didn't accept the delivery, and one of the respondents even burned the order.
Yes, that's correct. That's correct. So Don Smith burned the order, so that's what the police did. The sheriff did. The order itself said that paragraph 21, the notice of motion and the injunction order is to be posted at the corner of Thistlemore Drive and Surrey Street, and at this particular office, and then it's supposed to be delivered to any persons manning the barricade, right? And then the sheriff tried to do that. And this was not well received. Okay, so Don Smith, her view is that the court's authority simply does not apply to the members of the Six Nations, right? Any more than the authority of an Ontario judge would apply in Illinois, right? Because her view is that the court is a creature of the Canadian state, and the Six Nations are not subject to the Canadian law, and this is a matter of nation-to-nation diplomacy. Okay, so that's why she burned the order, and many of the protesters would agree with her. Okay, so paragraph 24. We hear about this order to a motion to renew, motion to continue Matheson and Jay's injunction. Renew just means renewing it. Had been scheduled for March 9th. So why was this motion to continue necessary? We have an injunction in place. That injunction has not been appealed, let alone overturned. Why was it necessary to bring a motion to continue this injunction? We learned something last time about without notice motions. 10 days, a 10-day maximum. So that's up here in Rule 40, Rule 40.02, right? So if you are if you are going to go before court and you're going to ask the judge to make an order without notifying your adversaries, you are asking for an exemption from the audi alteram partem principle, and the law is reluctant to grant that. So it's not going to give that to you under any circumstances for more than 10 days. Okay, so now Henco is saying, we're back before you. This time we've provided notice to the other side. We want this injunction against the protest to be extended. And they also, not only do they want it continued, but they also brought a motion asking the court to find the respondents in contempt for the breach of the March 3rd order. So what does this mean? Yet another word that we use in everyday English, and then we come into a civil procedure classroom and this word has a specific meaning. It happens when a court order is disobeyed. This court has someone to do something and they don't do it, right? So in principle, every judicial order has the force of law, and if it's disobeyed, then there's a consequence, just as there would be a consequence for disobeying a provision of the criminal code. Okay, and that's exactly what's happening here, right? There's an order to dissolve the protest, and it's not happening. So Rule 16.11 in your readings is the foundational rule for contempt orders. You'll notice that there are unusually stringent procedural requirements for this motion. This is a motion like the other motions we've looked at, but there's special rules, right? So one of them is here. You can only get a contempt order from the judge in the proceeding in which the order to be enforced was made, right? So you can seek other motions. You can just sort of generally file the motion with the court, and whatever judge is available will hear the motion and can grant it. Here it has to be the judge which has been sort of assigned to the case and heard other stages of the proceeding. The notice of the motion shall be served personally, right? So you remember, personal service is our gold standard for the delivery of a civil litigation document. It's expensive, it's a pain in the butt, it lends itself to game playing on the part of the defendant, but we require it for the most important documents, and this is one of them. Right? Just like an originating process statement of claim is important enough to justify a personal service requirement because it's what tells people for the first time that they're sued. Here, we have, again, a personal service requirement where it's not required for most types of motion. Again, another example of this kind of stringent procedural requirements for contempt motions. The affidavit, you recall, of course, that every motion record has to be accompanied by an affidavit, which is to say a piece of evidence justifying the motion sought. And the act on your contempt order may contain statements of the deponent's information and belief only with respect to facts that are not contentious. Okay, so let's try to unpack that. We've got this business of statements of the deponent's information and belief. What are statements of the deponent's information and belief? And how do they differ from other statements that one might find in an affidavit? Statements of information and belief are not as good, right? The law of evidence considers this hearsay. We consider a document more reliable when it attests to the personal knowledge, personal experience of the deponent. So again, these are all things which specify a more exacting standard for a motion for contempt compared to a motion for other things. So why is this? Why are we putting a higher standard, requiring a higher level of evidence, a higher level of service, and a higher level of sort of procedural exactitude of someone seeking a motion for contempt compared to someone seeking a motion for anything else? Okay, contempt is serious, but lots of, yeah, that's the really important thing right here is that the consequences of contempt order include imprisonment or a fine, a monetary fine, right? If you bring a motion to have someone, oh, I brought a motion for particulars, you know, big deal. The defendant can be ordered to provide particulars, or you know, they can be allowed, the plaintiff can be allowed to serve the document in a different way. Big whoop, right? Here we're talking about putting someone in jail, taking their money. So we've got these heavy procedural requirements. Okay, so we've got our contempt motion. We've got we've got a contempt motion, and we've got an effort to extend this this injunction that was originally granted. Okay, so we now come to a different judge. Before it was what was his name? Justice Matheson. Justice Matheson was on before. Now we've got Justice Marshall. Who is going to be an important protagonist, to say the least, in this story. Okay, so he comes onto this case, and he hears this. He's not a fan at all of these protests. He hears this motion on March 9th. He grants it. He makes the injunction permanent. He adjourns the contempt hearing. So this is a power the judge has. If someone's asking you for X and Y, you can say, I'll grant you X, but you need to come back and argue further about Y on a different day. He orders service of this contempt motion, notice of motion, using those same methods they used earlier. Go to this corner, nail it up on this post, next to where the protest is happening, and deliver it personally to anyone who's actually at the barricade that day. 10 days later, March 16th and 17th, we have the actual contempt hearing. And we'll talk about the criminal versus civil piece in a bit. But what you need to know for now is that this is all about whether these people have disobeyed the court order, and if so, how they should, what sanction or remedy should be applied to them if that's the case. There's no evidence from the respondents, from the actual protesters, but Don Smith does appear. So what does Don Smith ask for at this contempt hearing on March 16th to 17th? Find it at paragraph 26 of the judgment. She kind of turns the tables on Justice Marshall and calls him into question. She asks him to recuse himself, which is to say remove himself from the case and have another judge hear it instead, because he owns land in the Haldeman tract, right? So what does this have to do with anything? Why might that give rise to a recusal motion. Bias, that's right. So she says he has a pecuniary interest in the outcome of this case. Yeah. So most people would agree, based on the limited facts you have, with Don Smith, that he should be recused himself. Not to get into it, but I think the other side of it might be that judges usually live in the area where they preside, and if you own a home there, then in principle, any legal question that affects property values would give rise to financial bias. But there's definitely evidence that this may have gone beyond the average level of financial stake that a judge has in what's going on. Okay, so he refuses to do so. He does not recuse himself from the case. So they hear this. The protesters want to lead the evidence of this historian, right, which is going to be evidence about how and why the land in question was originally alienated from the Six Nations. Marshall declines to hear that evidence, which he says is not relevant, and he makes a finding of contempt, that the protesters are in civil and criminal contempt of court due to not obeying the earlier injunction. Okay, so the lawyers for the defendants asked for a show cause hearing. So this is another bit of lingo that's explained in the footnote here, right? That this is a hearing where you have to specifically prove contempt of court. Again, an example of the sort of heavy procedural burden which applies to contempt of court because of the serious consequences that are going on. Often this will happen in this case, and we'll get to the Court of Appeals view on this in a few minutes, but Matheson did not choose to do so. So Matheson's view is that there's already ample evidence that these people have disobeyed the court order, and that in of itself is contempt. Okay, so after that, he goes to the penalty phase, right? So there's the finding of contempt, and then there's the question of, okay, what are we going to do about it? Somewhat like in a criminal procedure where you'll have the finding of guilt, and then you'll have sentencing. We don't use the word sentencing here, but we use the concept of penalty phase, which is sort of similar. Okay, and what does he decide? What does Matheson order as the penalty, and why? Yeah, it's not exactly probation, because it's not a criminal sentence exactly, but it is suspended. Which is to say that they will not have to actually be imprisoned so long as they do this, right? They have to go to jail, they have to go through this sort of procedure, the fingerprinting and so forth. But if they comply, then that will be the end of the matter. So what this illustrates here is that when people are incarcerated for contempt, it's more about coercion and compliance and less about punishment, right? The point of incarcerating people after a contempt finding is to coerce them into obeying. It's less about punishment, which is to say sort of or retribution on them for wrong things they've done in the past. So that's why you will very often see this type of penalty after a contempt finding, where the person, if they do X and Y, if they comply, then they don't have to pay the money, or they don't have to be imprisoned. Okay, and then going forward, paragraph 33, we see some sort of clarification about the circumstances in which they will or will not be arrested. Okay, so maybe the idea here was that this will be kind of like it's supposed to be a stick, right, to kind of threaten people into complying, but it does not work that way, right? 3 weeks go by, the protests are continuing. Paragraph 34, we see that 21 more people are arrested pursuant to that contempt order. This basically serves as fuel on the fire, right? Many more protesters join them on the land. This bridge is set on fire. A bag of rocks is thrown at a police officer who's seriously injured. The OPP, this is paragraph 36, brings criminal charges against 53 people. So this is really turning into a huge conflagration, right? And people are furious. It's all over the news, and it's a really bad month, particularly in April of 2006. However, by May 9th, things are calming down to some extent. Right? So paragraph 43, we see that this negotiation process has begun, what's called the main table negotiations, where representatives of both provincial and the federal governments and representatives of the Six Nations are sitting down and talking things over. The blockades are actually being removed by May of 2006. So this judgment that you read, the appeal court judgment, comes from the end of the summer. It was heard September 25th to 26th, well, almost exactly 13 years ago, of 2006. And by paragraph 44, we hear that by September, the protesters had removed all of the barricades and almost all of the acts of civil disobedience had come to an end, and only a small group of protesters left on the site. So the protesters, basically, most of them did exactly what they were ordered to do in the initial injunction that was granted. So the question is why, right? Why did they comply? And it's entirely possible that the contempt order worked the way contempt is supposed to work. It's sort of a stick and a threat, and people didn't want to go to jail, so they did abide by it. But at the same time, there were also these negotiations, right? So it's not clear whether the protesters would have left and the barricades would have been removed in the absence of the negotiations. And Justice Laskin says these negotiations did achieve some progress. Okay, so what you read is the Court of Appeal's judgment on the appeal of Justice Marshall's orders. And Laskin begins by noting that, that what Justice Marshall did was unusual in several ways. First of all, and this is paragraph 46, these orders he made were made on his own motion. Right? On his own motion, he ordered the parties to appear before him to make submissions on the status of the enforcement of his contempt order. He did so on these 4 occasions, right? So it was Henco which originally brought the injunction motion, and Henco which originally sought the contempt order. But then Henco sort of stopped coming to court for reasons that we'll see in a second, and Marshall, on his own motion, brought all these parties before him on 5 dates and required them to make submissions as to the status and the enforcement of his contempt order. So this is a deviation from the party control principle. The party control principle means that usually nothing happens in your civil action unless one of the parties brings a motion and asks for something to happen. Right? Or puts the matter down for trial, conducts discoveries, and so on. The judges don't generally take their own initiative. Here, Marshall rather decided to have these hearings on his own motion. So he, in other words, is kind of like coming down. Remember, we said that we in our adversarial justice system, the judge stays up here, right? And it's up to the parties to sort of take the steps and bring forward the facts and the law to the judge, who stays up there and makes the decision. Here the judge is coming down into the forest and demanding explanations and demanding the parties to do something when no party has asked him to do so. So why did Justice Marshall take this unusual step? Judges are used to sitting back, waiting for the parties to bring a motion and then trying to adjudicate it fairly. From his point of view, why did he feel this necessary? Can anyone elaborate on why the rule of law is, in Justice Marshall's view, implicated here? What does this have to do with the rule of law? Orders are not being taken seriously. Okay, yep, that's true. And who does he blame? Who does he blame for this, right? Because he's definitely, people are right, he's got to be in his bonnet about the rule of law and about the orders. But he's not just mad at the protesters. He doesn't just blame them exclusively for what's happened. Who else does he see as responsible for this breakdown of the rule of law? Yes, the OPP, that's right. The OPP and the Attorney General, right? He sees the Attorney General and the police as responsible for enforcing his contempt order and arresting more people, and doing so until the contempt order is obeyed. Because up to this point, the OPP has arrested some, but not all, of the protesters who were not complying with the order. Why do you think the OPP was not arresting everyone they could lay their hands on who was remaining at the barricades? It's never precisely, well, it's a good point. It was vague, right? But it was clarified. The contempt order was clarified as of April 28th. The April 28th order, right? The AG said, well, why don't we clarify this? And after March 28th, the contempt order was quite clear, and there were people who were in violation of it, but the OPP did not fully enforce the contempt order and declined to arrest some of the people whom the order said should have been arrested. Okay, bad optics. Yeah. I mean, it would be on the news. This was a lot of media coverage at the time. But what else? It's not just about optics. If you were representing the OPP and speaking to this, why might you say that they didn't necessarily arrest everyone they possibly could have? Yes, that's right. Natalie's got it right. This is, this was in the spring a really bad scene that could have gotten, drastically out of control, led to riots and major civil unrest in this area of Ontario. And it was calming down by that point. And the more people you arrest, the more fuel you are potentially throwing on this fire from the OPP's point of view. Okay, so let's come back now to the Hennings, right? The Henco, the company that originally started all of this. A very important fact comes up at paragraph 49. The Henco brothers, they sold Douglas Creek Estates to the Ontario government, right? So while the protest is still going on, dying down a bit, but still going on, the Ontario government buys this land. Why? This was so dangerous and was such a threat to civil order in Ontario that buying this land from them and letting the protest continue was a way to try to calm things down and avoid any further violence. Okay, so in the agreement of purchase and sale between Henco and the government, one of the terms says that the contempt order has to be dissolved, right? So Henco in this agreement, they agree in exchange for the money to seek dissolution of this contempt order, and they don't mind doing that, right? Because Henco has now been made whole. They've got their money. They can walk away. There will be other subdivisions for them to subdivide. So, and of course, this contempt order was granted in Henco's favor originally, right? They're the ones that sought it. So, by the party control principle, it seems logical that they should now be allowed to dissolve it, to do their deal with Ontario. So they bring this motion, and of course, no one opposes the motion to dissolve the contempt order. So it should be a slam dunk. But they counted out Justice Marshall too soon. What did Justice Marshall do next after Henco brought this motion seeking the dissolution of the contempt order against the protesters? So we've got an injunction, right? Then we've got Henco brings a contempt order, contempt motion's granted. Now they want to dissolve that contempt order, right? Which normally you can do. Why won't Justice Marshall grant it to them? The rule of law, he says, is not functioning in Caledonia. So, this rule of law, right? This is a complicated idea, right? We were talking about the rule of law on Thursday in the RJR case, where the government said, "Look, the Quebec Court of Appeal has, said our legislation is constitutional. So the rule of law means you've got to abide by the Quebec Court of Appeal's order unless it's overturned at the Supreme Court of Canada." Here we have, again, the rule of law on the table, right? So a very straightforward, simple idea, which is part of the rule of law, is that if a judge says that you have to do X, then and that order has not been overturned on appeal, then you got to do X, right? Unless and until it is overturned on appeal. And Marshall's saying, look, I made these orders, and no matter what Henco says about it, the orders were not abided by, and that means the rule of law is not being respected. So on August 8th, he goes so far as to suggest there should be no more negotiations until the orders are complied with, although he doesn't actually order that. Right? So from his point of view, these negotiations are kind of offering the protesters a reward for their contempt and for their illegal action. So we've got a protest which has been found to be illegal. We've got an order that people leave. We've got people not abiding by it. And then at the same time, we've got the government sort of coming to the table and offering concessions. And Matheson doesn't like that because he says that that's basically incentivizing them or rewarding them for their contempt and their illegal behavior. Okay, so that's good. Let's move on. Okay, so again, we've got what you're reading here is an appeal of Justice Marshall's contempt findings, and the parties to that civil action were Henco, and then Don Smith, and then the other protesters, and the Attorney General, and the OPP, right? So all of these, they're all parties in this litigation. Nevertheless, at paragraph 40, we hear from some other people, right? So paragraph 40, we hear about the perspectives of the residents, which is to say the non-native people who live in this area. So given that they're not parties, right, and given that we have a party control principle, why is Laskin talking about what these non-parties think? Usually civil litigation is just the facts and the arguments brought forward by the parties. But here we've got people who are not, they didn't bring the injunction, they weren't subject to the injunction, they haven't been found in contempt of court or anything else. Who cares what these people think? They're stakeholders. Okay. Okay, interesting. And what is their stake? They live in the area, and they're affected by some of the things that happen, right? Them claim that they've their ability to use land and enjoy their houses and so forth has been interfered with by the protesters and by the police. So the way the court hears from these non-parties is through an amicus curiae. What is an amicus curiae? All right, you all nailed it, right? So a friend of the court needs a friend because the parties themselves cannot or are not able to put forward facts and evidence the court needs in order to do justice. Okay, so that's the local residents and their perspective. Paragraph 62. We finally get into Justice Laskin's reasons on the several sort of intertwined issues that were before the Court of Appeal. So the first question is, was it an error? Did the motions judge err by refusing to dissolve the Henco injunction unconditionally? So this is about paragraph 2 here, right? So Henco, the contempt motion was granted to them originally. Now they've come back, they want it dissolved. Matheson says, yes, but only if the criminal contempt has been disposed of. So this injunction, right? This injunction against the protesters was granted in favor of Henco. The injunction now operates in favor of the provincial government, because the provincial government is the successor in title to Henco, right? And when it's an injunction about land, it runs with the land. So if someone different comes to own that land, the injunction now runs in their favor. So the legal question here is, if the party in whose favor an injunction operates wants that injunction dissolved, is that in of itself sufficient grounds for dissolving that injunction? So if you think back to RJR, right, to our tobacco companies, and they want an interlocutory injunction saying we don't have to change our packaging until the Supreme Court of Canada has finally dissolved or disposed of the issue. So if RJR got that injunction, but then they wanted it dissolved, right? They say, well, we don't want that injunction anymore. We want the Tobacco Controls Act to apply as legislated. Could someone else protest, right? Could the corner store operators or the printers of the packaging or whatever say, no, we want that injunction to stay in place? And what does the Court of Appeal decide about this legal question, about the grounds for, or what is necessary to have an injunction dissolved? Look at paragraph 64, you'll see what they decide here. Yes, that's right. That's right. So the upshot of all that is that if Henco and the Ontario government want it dissolved, want the injunction dissolved, then it should be dissolved. Period. End of story. The only person opposing the dissolution of the injunction is the amicus curiae representing the residents, and they're not a party. So that's not good enough. The party control principle applies here. And injunction interferes with the government's property rights. This land belongs to the government. And if they decide that they want to let the protesters stay there, then that's up to them. And there's no legal basis for anyone insisting or requiring that injunction remain when they, the owner of the land, don't want it there. Okay, so there's a long discussion where they're sort of distinguishing legal principles, but that's basically all you need to know coming out of that. Justice Marshall had a second argument for why the injunction should not be unilaterally dissolved. Right? He says, paragraph 75, the motions judge sought to support paragraph 2 of his order on a second basis, the exercise of his discretion. So Matheson was saying, look, it doesn't matter what Henco wants. It doesn't matter what the government wants. This is about contempt of court. This is about the rule of law and whether or not we're going to have a society where court orders are abided by. Therefore, Matheson says, the court is entitled to continue the prosecution of this case for the reason that defiance of court orders transfers the conduct in question from a mere civil contempt to the realm of public depreciation of the authority of the court and tend to bring the administration of justice into scorn. Okay, so that's what Matheson says. Laskin has kind of a subtle response to this, right? He doesn't dismiss this idea completely. Paragraph 76, Laskin says, the motions judge was right to be concerned about the defiance of the injunction. However, paragraph 77, the dissolution of the injunction would not have prevented past breaches of that injunction, from being addressed in contempt proceedings, right? So basically that, even if you dissolve this injunction, acceding to the request of the Ontario government and Henco, Justice Matheson, that does not deprive you of the ability to impose penalties for contempt which had already occurred in the past when the injunction was still in place. So that's where he comes in on that. The second issue, the second thing that was under appeal here was the first paragraph of Justice Marshall's order, right, where he says, this matter of contempt is referred to Attorney General for carriage, and that in the course of a time will be set so the court and the public may be apprised of the Crown's progression or lack thereof in regard to criminal contempt. The court will remain seized of the matter until it's resolved. So what Matheson was basically saying here is, look, you government and you OPP, you've got to bring your butts back here every 2 or 3 weeks and let me know how things are coming along with the enforcement of my contempt order. How many people have you charged? How many people are still there? Why have you not yet, assuming you have not yet, fully enforced my contempt order in the way that I ordered? So he talks about a case management meeting. So a case management meeting is basically where the parties come before the judge and they discuss how the case is going without getting into the substance typically of the actual dispute. They talk about the procedural issues that may be outstanding. Case management in general refers to a process whereby a judge takes a more active role. Right? So anytime you have case management, that's in tension with the party control principle, because it means the judge will be doing things like imposing particular timelines and being more activist in terms of saying what the parties are going to do going forward to move the case. Okay, likewise, remaining seized. Remaining seized means that the judge is going to retain jurisdiction over the case. Typically, when a case ends, the judge loses their jurisdiction over it. And even in a normal civil action, if you bring a motion to a court and Justice X hears the motion and grants it or doesn't, once that order has been given, that judge is no longer seized of the matter, right? And for the next motion or for the trial, it will come before the court again, and it might be a different judge hearing it. Where a judge remains seized, that Matheson J is saying, oh, no, you're not going to get a different judge next time. This is like my thing, right? And I'm all about the rule of law and making sure you guys abide by it. So don't think you can weasel out of it by getting a more chill judge, hearing about this when you come back again in 2 weeks. Okay, so this was also appealed, right? And the Court of Appeal deals with this starting at paragraph 87. First of all, by dealing with the question of whether there even remained anyone in contempt to deal with, right? Do any contempts remain to be case managed, right? Because if there's no one still in contempt, then there's the whole justification for this case management remaining seized piece is off the table. So, and their answer is yes, right? They sort of break down the different periods of what went on, and ultimately they conclude that yes, there were some people who were still in contempt. Therefore, Matheson J was not wrong to remain seized. So the key paragraph here is paragraph 96, the Court of Appeal. So this is a lawful exercise of the motion judge's discretion. Contempt of court forms part of the court's inherent jurisdiction. What is inherent jurisdiction? Have you seen that term before? Courts receive their jurisdiction from different sources. What's inherent? Okay, so inherent jurisdiction is something which courts can do of their own power without having that power granted to them by any statute. Right, so some of the powers that courts exercise are there because a specific statute says the court can do it. For example, the Courts of Justice Act or the Rules of Civil Procedure. Where it's inherent jurisdiction, that means that even if there were no Courts of Justice Act or Rules of Civil Procedure, as long as there is a superior court, it will have the power to do certain things. And contempt is part of this. Contempt is the means by which the law provides to protect the court's authority from improper interference. As the motions judge recognized, the rule of law depends on the court's ability to enforce its own orders by punishing for contempt. Where no other party has done so, the court may, in its discretion, even initiate contempt proceedings on its own motion to ensure that its process and authority are respected. So this is all about, again, how unusual contempt motions are. And here it's the point that when you're talking about contempt, you're no longer just talking about, prejudice or doing fairness as between parties. You're talking, in some sense, about the rule of law and whether we're going to have courts which are obeyed or not. Therefore, judges are allowed to be more activist when it comes to contempt. And they can, on their own motion, without any party asking them to, initiate contempt proceedings if a party has is in contempt of court, is disobeying a court order. Okay, so far, Laskin seems to be siding with Justice Marshall on this point. But Marshall's not yet in the clear, because there's a point here about the operational discretion of the Ontario Provincial Police and the Attorney General. So did anyone catch this? I mean, this was deep into a long and complex case, so maybe not, but did anyone figure out what this is about? Because we're talking about sort of this sphere of discretion that the police and the Attorney General have. And Justice Laskin for the Court of Appeal is worried about that being trampled on. So it comes to paragraph 112. So the process the motions judge has used to date has been unfair in two important ways. First, he improperly interfered with the OPP's operational discretion in the enforcement of the law and the Attorney General's prosecutorial discretion. So this is really an argument about spheres of authority, right? So, we have the court system, and yes, the court system has inherent jurisdiction to enforce its authority through contempt. But then we have the police and the Attorney General, right? So the Attorney General directs the Crown, right, and determines who's going to be charged with things. And the police have their own sphere of discretion. And neither statutes nor courts are going to instruct the police about who to arrest, when, and where. That's the discretion of the police. And Laskin says that the lower court went too far into the OPP's sphere of operational discretion when he started trying to tell them, you got to arrest these people and you have to do it on this particular date, and so on. The courts should not be telling the police who to arrest, and as far as the Attorney General goes, courts should not be telling the AG, the Crown, who to charge, even when you're talking about contempt. So the case, in many ways, is all about like, these big, important institutions and kind of how they bump up against each other, and how border disputes over the discretion of one institution relative to another are resolved. And here the Court of Appeal is delineating the border between the discretion of Superior Court of Justice to enforce its authority through contempt, and on the other hand, the authority of the OPP and the authority of the Attorney General to exercise discretion over who is arrested when and where and who is charged. And the lower court went too far into that sphere, according to Justice Laskin. So even in cases of contempt, you cannot micromanage what the police do unless they exhibit bad faith or otherwise act improperly. We'll get to that part in a second. Especially where contempt is outside the face of the court. Okay, so here we have another set of distinctions within contempt, within the general concept of contempt. Contempt inside the face of the court and outside the face of the court. What does that mean? What does it mean for contempt to be outside the face of the court? Yes, literally inside the court. That's right. Yeah. So if you're in court and the judge is there and he says, I ordered you to do X, Y, and Z by next Tuesday, and you say, screw you, contempt in the face of the court. Outside of the face of the court, you know there's a court order, and you just don't do it. But you're not in the court when you're doing it. Okay, so this is contempt in this case outside the face of the court, and that makes it especially unlikely that the court is gonna be allowed to engage to tell the police specifically what to do, right? If someone does flip the judge the bird in court, then the judge would be well within their authority to tell the police officer, the court security officer who's there in the court, to eject that person from the court. To take a really dramatic example. Okay. So paragraph 117, the Court of Appeal talks about how many different things there are in consideration here, right? So this is kind of justifying why prosecutorial and police discretion is so important here. In this present case, many considerations are at play beyond the obligation to enforce the law. Aboriginal treaty rights, constitutional rights, right to lawful protest, concerns about public safety, and importantly, the government's obligation to bring about the reconciliation of Aboriginal and non-Aboriginal peoples through negotiation. So basically, compliance with court orders is important, but it's not everything. And this is one of the reasons we're not going to let the lower court judge, micromanage the way the OPP and the Attorney General deal with it, especially in the lack of, or because there is no evidence that either the OPP or the Crown exercises discretion improperly or in bad faith. Okay, so far, Matheson is in trouble for trampling on the sphere of discretion that the police and the Attorney General should have. But he's in trouble again for trampling on the rights of the protesters, on the rights of the alleged contemners. So here, to explain this point, the court talks about civil versus criminal contempt, right, at paragraph 85. So anytime you've disobeyed a court order, then you have engaged in civil contempt. Criminal contempt is where it's more serious. So it's not just a disobedience, but you've actually interfered with the court's process or seriously threatened the proper administration of justice. So both civil and criminal contempt can happen in the face of the court or outside of it. And either can get you incarcerated, right? So it's a common misunderstanding that only criminal contempt can lead to incarceration. Not the case. Civil contempt can also lead to incarceration, but incarceration used to coerce compliance, not incarceration for punitive purposes. So in this case, the protesters were found to be both in civil contempt and criminal contempt, right? This was Justice Marshall's order on March 17th. And there was this 30 days in jail, but suspended sentence, so you don't actually have to be imprisoned if you comply. And basically, the problem with what the judge did was that the contempt order, by the contempt order, the motion has convicted and sentenced numerous individuals without affording any of them even the most basic procedural fairness. And procedural fairness was breached in three ways. So this is paragraph 124. So he found a class of unnamed persons guilty of criminal contempt, right? He said all of the protesters are guilty, and you, OPP, have to go out and arrest everyone who is in that guilty class. Under our criminal justice system, a court, not the police, determines individual guilt and innocence, right? So if before someone can be guilty of something, a court has to find, as a matter of fact, that this particular person did this particular wrong thing. Not just like anyone who has done X has breached the law, and you, the police, go out and decide who is in that category of X. Secondly, paragraph 125, this order operated prospectively. He tried to find people guilty of contempt in the future. So anyone who has not complied in the future will be in contempt. You can't do that. Criminal contempt has to be retrospective. It has to be an adjudication based on something that you have already done. And finally, at paragraph 127, he sought to say that people who were arrested would be automatically convicted and sentenced. Again, that's not allowed, right? You have to give each protester an opportunity to be heard, an opportunity to call evidence and be represented by counsel. Because, for example, someone might say, well, I wasn't actually there, right? The police arrested the wrong person. Or, you know, I was there for some other legitimate purpose. I wasn't part of the protest or something like that, right? Whereas he sought to have the police go out and arrest everyone who was there, and then say, okay, once you've arrested them, police, you have to take them to jail, have them fingerprinted, and so on. So again, when you're talking about contempt and you're talking about the potential of incarceration, and when you're talking about criminal contempt, which is a crime, the procedural rights that go along with that have to be respected. And these are different ways that he breached it. Okay, so we'll quickly deal with the last, the question that the court got to of what the contempt term be going forward. And basically here, this paragraph 1 is going to be upheld, right? Because they're not departing from this important idea that people have to abide by court orders, and the contempt power is there. But there's some variations, right? So basically they're trying to walk, we don't have to get into the details, but they're trying to walk the line of maintaining contempt and not excessively circumscribing the right of of a judge to enforce court authority through the contempt power, but insisting that that be done in a way that respects the procedural and due fairness rights of the alleged contemners, as well as respecting the operational discretion of the police and the Attorney General. Okay, so there's three concluding comments here, right, where they talk about importance of negotiations. The judge, he says, was wrong to suggest negotiations should stop, especially given what the Supreme Court of Canada has said about negotiations and Indigenous land claims. Then they talk about the rule of law, right? The rule of law is great, obviously, but it has many dimensions, and they're basically saying it's not just about, you know, bringing maximum coercive force on people who don't abide by court orders. And then they have nice things to say at the end there about, you know, the motions judge isn't such a bad guy after all. He was there on the spot. He's a member of the community, yada, yada. Okay, so lots of takeaways from this case. The case talks about party control of civil litigation and what the limits of that are. The case tells us about contempt as a special motion, right? And how sort of the normal rules and how we think about motions change when we're talking about contempt. And it reiterates that the idea of procedural fairness is not thrown out the window just because we're talking about contempt, nor is the discretion of other areas of our justice system, like the OPP and the AG, nor do they lose their operational discretion just because we're talking about contempt. Okay, so that brings us to the end of our official time together. It's a complicated case. I hope that that these slides at least kind of brought out the important parts. Please do let me know if anything is unclear. Okay, so thanks for bearing with me. It's you can breathe a sigh of relief because that's probably the toughest case in the course. So barring any questions, I'll say thanks very much and look forward to seeing you on Thursday.